Good morning and welcome to session 4 of the 9th Annual Fair Housing Conference presented by GBLA's Fair Housing Law Project. My name is Cassie Mullican. I'm the Marketing and Communications Coordinator here at GBLA. We are happy to introduce today Christopher Brancart as our session 4 speaker. A couple quick notes before I go into introducing Chris. This session is recorded. All attendees are on mute mode in addition to unable to access camera view. If anytime you have questions during the presentation, please feel free to either use the raise your hand option, use the chat box, or type your question in the questions. We'll do our best to get to those towards the end of the session. Just a few housekeeping rules again. All attendees are muted and I'll only be able to unmute you with your hand raised. So with that, I'm going to go ahead and make the introduction and we'll get the presentation started. So today's guest speaker is Christopher Brancart. He is a partner in Brancart & Brancart, a law firm located in Pescadero, California, specializing in federal fair housing litigation. He practices with two partners, Elizabeth Brancart and Liza Cristal Damon. I'm hoping I said that right. Following law school, he clerked for the Honorable Vincent McCusick, Chief Justice of Maine, and then taught appellate advocacy and administrative law at Western State University College of Law. From 1987 to 1989, Chris worked as a staff and then supervising attorney at the Legal Services Program in Pomona, California. Since entering private practice in 1989, Chris has focused on litigating cases that expand fair housing rights, devising methods that improve fair housing investigations, and supporting fair housing attorneys and advocates through trainings and co-counseling. We're excited to have you here today, Chris. I'm going to go ahead and hand over roles here for you, so you should be able to present.
Fantastic, thank you. And Cassie, thank you for that kind introduction. If I have done this correctly, everyone should presently see on their screen a poster that appeared throughout San Francisco in about 1878-77. Cassie, do you see that?
We do see the screen.
All right. Let me go ahead and I, however, do not. I have filled myself with the screen. All right. So if I could, let me see. Oh, there we go. Fantastic. I start today's presentation with this poster because I think oftentimes we forget how far we've come in achieving fair housing. Not only do we see that in the data that HUD puts out every 10 years when it does the housing discrimination survey, but we also see it with our own eyes and experience that we are living in communities that are much more diverse and integrated in most, but not all, parts of the country. It is remarkable that we've been able to transform our country in this way, given our history of discrimination, particularly discrimination in housing, and a specific type of discrimination in housing, discrimination at the hands of municipal and local government. The pictures that you're seeing on your screen presently are pictures of life in San Francisco during the 1870s, 1880s, within an area called Chinatown. It was an area set aside within the city of San Francisco in which Chinese immigrants first coming to build the railroads and then settling within the city to become the largest population of Chinese individuals outside of mainland China for a long period of time. The reaction of the city of San Francisco was extraordinary. We think of San Francisco as being a place that is in the forefront of human rights and remarkably liberal city. In fact, most of the most draconian, overtly discriminatory laws that you see adopted in by municipalities in the 1880s are those that are adopted by the city of San Francisco. Right here, if you see on your screen, you see a gentleman in a derby, and he is placing people in what's called county jail. And what this picture illustrates is that the very first occupancy restriction, we often think of it in fair housing about familial status cases, but the first occupancy restriction adopted and enforced widely by any municipality was in San Francisco. And it was enforced to target landlords who were renting to Chinese immigrants. And if there was excessive occupancy in the eyes of the city, the city inspector would arrest not only the occupants in the dwelling, but also fine the landlord. Closer to home, where I grew up in my sort of formative years in East Texas, I still recall seeing faded signs in gas stations, mostly in East Texas, up along the Louisiana border, in which they still had designated, quite faded, but still designated, colored written on bathroom doors. We've come a long way, but I am struck by the fact that we seem to have stalled in our ability to provide open housing access and to provide housing for our citizens, our residents. And I oftentimes, when confronted with a conundrum that I can't quite understand, how is it that we've come so far from the images I just showed, and yet we've gone ahead and stalled? I can see my computer is telling me that it's going to run out of gas, so I'm going to plug in. And so what I do typically in situations like this is I will go ahead and try to do some historical research. My historical research led me to a series of cases that I want to share with you that begin, I think, the story of why we have stalled in our ability to provide housing for our people. If you should see on your screen presently an article from the front page of the Baltimore Sun in 1913. This was a report regarding a special session convened by Mayor Preston. Mayor Preston was seen as a liberal, progressive mayor of the city of Baltimore. And as part of his progressive agenda, he sought to improve quality of life in the city. The first thing that he believed needed to be done in order to improve quality of life was to enact a segregation ordinance. The segregation ordinance of Baltimore in 1913 was the first in a series of such ordinances that were adopted throughout the United States, mostly in the southern states. What the Ordinance of Baltimore said, and what spread to other cities, was that where you had a block that individuals, households were to be designated as white households and black households, and that where you had a block that was predominantly white as of the effective date of the ordinance, then no new homeowners or occupants who were black could move into that block. In other words, whoever had the majority based upon race within a block, that block would be designated as a location for only that race. What you see on your screen now is a map in which there was an attempt to implement part of this racial segregation by separation between black and white households in Baltimore. As of 1906, this was the map, and then it was drawn on it by the Mayor Preston and his folks to show where he felt the city would begin to self-segregate pursuant to the new zoning ordinance. Mayor Preston's idea of segregation as an improvement to the quality of life within cities was widely held by progressive municipal reformers in the wake of Plessy versus Ferguson. You recall that's the decision that implemented separate but equal as being constitutional. And in a strictly formal sense, what the Supreme Court says in Plessy versus Ferguson is that so long as facilities are equal, they may be separate. And that is absolute equality, according to the Supreme Court in Plessy versus Ferguson, because it guarantees equal services, albeit separate, based upon race. It was called the equal application doctrine, that so long as everybody received the same level and quality of services, whether it be municipal services, transportation services, schools, there was no offense to the Equal Protection Clause of the Constitution. This concept of separate but equal, notion that we should grow as two separate peoples, something that within my lifetime was expressed widely by, for example, the apartheid government in South Africa, was something that really caught a hold of the progressive mind, something that we oftentimes, if you read history, you don't think about, because you think of progressive as being liberally minded. But in fact, this notion of segregating our cities would be a source of municipal improvement was widely accepted and became incorporated in most of the planning documents at that time. And that you can think that we are emerging after the Gilded Age and prior to the First World War into a period of time that you're seeing rapid urbanization. You're also seeing widespread schooling, and you're seeing the rise of experts, and the notion being that we can manage people and manage cities to the betterment of all, the first step of which is segregation. Following the adoption of the Baltimore Ordinance that was led by Mayor Preston, the cities of Wilmington in North Carolina, not Delaware, Richmond, Atlanta, and others adopted the Baltimore Segregation Ordinance. In each of these cases, the city prescribed that wherever there was a majority of persons, they would take a census of blocks by race, and wherever there was a majority of one race, white or black, and it was strictly a white or black system of segregation they imposed. Wherever there was a majority, that block would be deemed going forward as being a location where only the predominant race could occupy. So over time, the belief was that we would segregate our cities into white blocks and black blocks. How is it possible? How is it possible that this was seen as implementation of equal protection? Remember, we're talking 1913, 1914. We are just in the cusp of the beginning. We haven't yet entered the First World War. And so what I tried to do in the late night was to try to understand how it is that the leading legal scholars of the day reacted to the passage of these ordinances. Here's, you should see on your screen, I hope you do, it's an excerpt from the Harvard Law Review. This Harvard Law Review was responding to one of the cases that was adjudicating the legality of the Baltimore Ordinance scheme, separating blocks by race. And as you can see here, it is a piece of its time, indicating or suggesting that the races, in this case black and white, should be separated. In 1917, something quite remarkable happened. In 1917, the Baltimore Ordinance that had been adopted by the city of Louisville, Kentucky, was challenged by a brand new group. This new group had mostly been agitating on anti-lynching laws, but had turned its attention now to the courts in order to enforce civil rights. The group is the NAACP. The first organized, deliberate, planned attack on racial segregation and discrimination by the NAACP was to challenge the Baltimore Ordinance, this segregation block by block based on race, in the city of Louisville, Kentucky. And the case, the Buckingham case, is famous not only for its unique historical background as to how it was assembled, but it is also famous for something that I don't think we recognize. It's the first time that the Supreme Court actually stepped back from Plessy versus Ferguson. What did the court say? The court said in the Buckingham case that segregating a city based upon race, block by block, was, although equal in application, overtly discriminatory and violated the Equal Protection Clause, as well as the Civil Rights Act of 1866, the progenitor of our modern day fair housing law. The Supreme Court rejected all of the justifications that have been provided by the city of Louisville, justifications that have been developed to justify the very same type of ordinance in Atlanta, Richmond, Wilmington, and also starting in Baltimore. The reaction to that decision, which by the way was unanimous, for a variety of reasons. We think of Justice Holmes as being sort of a great liberal light, indeed he was, as well as a forward thinker, but actually he tended to be a staunch supporter of segregation. But Holmes went ahead and went along with the decision, and it was unanimous. So we have in 1917 the first instance of the Supreme Court stepping away from Plessy versus Ferguson, separate but equal, and it does it by striking down as unconstitutional, a violation of equal protection, the Baltimore Ordinance system. We're going to segregate our cities block by block, either white or black, and significantly, it rejects the justification offered by the cities that this is for the betterment of the cities, it benefits both races, it encourages public welfare, safety, etc. Here's what I want to say. What was the reaction to this 1917 case by the leading lights of the day? So I went to the law journals. I went to Yale, I went to Harvard, Virginia, Michigan was also an active law journal at the time. Remember, this is more than 100 years ago. And it is striking to see how the leading lights, the great legal thinkers of the day, saw the Buckingham case as being, well, as being probably a misreading of the Constitution, and also undermining what they saw as good government. You see here the Yale Law Journal excerpt in which it talks about the rights of people to sell their property, et cetera, et cetera. But what is clear focus here is that the intermingling of the races is going to undermine the quality of life in the city of Louisville and other places that had the Baltimore Ordinance, but now must repeal it because it was deemed unconstitutional. The Harvard Law Review wasn't going to be left out. This is, of course, 1918, 1 year after the case comes down. And as you can see, it is this notion of the danger of intermingling or contacts between races, in this case black and white, that is seen as being sufficient justification for the Baltimore Ordinance. So the point to make is this: while the Supreme Court had read the Constitution to step away from Plessy versus Ferguson, separate but equal, did so for the first time in the case in 1917. The elites within the power structures, whether it be lawyers, municipal government, local state government, and even the federal government, did not agree and were deeply wed to this notion that separation of the races was going to be the source of better municipal government. You should see on your screen right now a picture of Baltimore. This is one of those famous maps that you'll recall, the home security maps that were issued in the 1930s by the federal government. And while it is true that Baltimore did eventually had to repeal its segregation ordinance, the fact of the matter is that what was not enforced by municipal law eventually became the fact on the ground, and the city became highly segregated. Not only was it highly segregated based upon the historical discrimination by localities, but it also was widely encouraged by the federal government. Throughout the 1920s, the Commerce Department issued a series of manuals about how to zone our cities, and it was reinforced with the rating system that was imposed upon neighborhoods by the federal government in determining whether or not to support home loans and how one values properties. In each of the cases, you'll notice that there are grades that are put onto neighborhoods, and those grades highly correlate to the predominant race within a neighborhood. To leave any doubt, along with these maps in the 1930s, evaluators went ahead and put in notes to go ahead and explain why it is that they coded a neighborhood first class, second class, third class, and here we see a neighborhood justifying that coding based upon the fact that African Americans are located in the neighborhood where there's a school for white children. One more map from this being Louisville, and where the famous Buckingham case came out of. And you can see there's still wide segregation based upon this rating system that used this first grade, second grade quality of neighborhoods that largely correlated to race. So here's what I want to say. We have come a tremendous distance in accomplishing fair housing. You saw the slides in the very beginning. We have changed, at least in the courts, as early as 1917, striking down municipal governments that tried to segregate our cities. We have the most robust civil rights protection for fair housing, open housing in the world. And yet, when you look around your neighborhoods, when you look around the cities that make up Southern California, what we see is, yes, a level of integration that is unique in comparison to other parts of the country, but you also see that we have not been able to provide sufficient housing for our people. In other words, it's great to have fair housing, but we need to have housing to be fair about. Why is it that we have stalled? Why is it that we can't seem to take the next step forward to provide true, genuine, open housing for folks in California, where the housing crisis is so significant. I think I want to offer, if I may, just my observations based on my life and having thought about these issues for a while, what I think the impediment is. And I guess where I'd like to start is my neighborhood. I hope you can see on your screen now a picture of a Google map, and it shows where the town of Pescadero, California is located. Pescadero is a small farming town. It's about 900 folks live there in southern San Mateo County, located between San Francisco and Santa Cruz. The town of Pescadero was one of the first communities that was permanently established in San Mateo County. It began its most rapid growth along with the gold rush, not because people sought gold in Pescadero, but rather it became the source of dairy and also food that fed the city of San Francisco 35 miles to the north, as people were flocking there to then leave for the Sierras and search for gold. The town was settled largely first by a handful of Spanish settlers, but it was, and by that time, the native Indian population that lived in Pescadero had largely immigrated inland. The first English-speaking settlers came to the town in the 1850s. Most of them came from the state of Maine, New England, and they grew potatoes. Today, it is a town that is largely agricultural, and within the last 10 years has become something of a tourist destination. The reason for that being is that if you were to expand out this map to the right, what you would see is Stanford and Silicon Valley are located about from the center of Pescadero, about 30 miles to the east. Well, that's my town. That's where it is. And this is a closer look at my town. There's a road called Pescadero Creek Road that comes from the Coast Highway, known as PCH or Highway 1. And what you see here in this picture is, well, it's my house. My house is, I don't know if I touch the screen, it's right here. And what I want to ask you or share with you, see that my house would be the one that is at the bottom of the U, where it says Pescadero Creek. So what is this? This is a town. It's a small town. Each of these dwellings that you see here are zoned or intended for residential use only. I'm not going to name names because they're my friends and my neighbors, but what I am going to do is just let's think about how are people actually living in this town. Each of these are supposed to be dwellings, either that or associated with agricultural use. But how do people actually use the housing? How do people actually live in the town of Pescadero? Well, if I were there with you, I would start in the left-hand side of this map. And I don't know if you can see my hand. Cassie, can you see this hand going around? Maybe not.
Yes, we can.
Oh, good. Well, right here, this is the barnyard that services the fields over here. This right here is a small of the original homestead that went ahead and went with the fields right here. You have back here, this is housing that's being used sometimes for farm workers or farm managers. To this location right here, this is my neighbor, and they operate a very important and thriving plumbing business. But their house is right here. This is my house right here. Here are my neighbors right here. And then to this side, there is a there's farm worker housing, unpermitted. And also there is a work shed, and we have a work yard here for farming implements because he farms cows. Over here, this family right here has moved to town about 8 years ago, and they actually operate a book selling business out of the back here in storage. My friends live here. I'll call them the Smiths. And the Smiths operate both a mail order business for computer parts, as well as they have a lovely garden, but they also operate a little outbuilding here in which they do work designing websites. Over here we have more farm worker housing, all illegal and unpermitted, as well as individuals back here are operating, are making food, which they sell throughout the town. And over here we have a family that went ahead in the front of their house. They opened up a business to pay for their housing. Over here we have, this is largely right here, unpermitted farm worker housing. And here we have the center of town, which has restaurants, there's a gas station and a post office. Here's what I want to tell you about this picture. There's nobody on my road, all of whom are wonderful people. But I want to say this, there's nobody on my road that's actually using their property as it's been sold by the town. Let me repeat that for you. The people that live in my town, and I think it will be true if you drive around the neighborhoods where you live, none of us are living in strict accordance with the zoning laws that have been imposed upon us by local government. And I'm sure there are many exceptions. Some of us live in gated communities. Some of us live in high-end residential developments. But my point being is that when you actually get to where people are living their lives, this being an unusual situation because it's a small farming town, what you find is that the life we live, our lives, our lived experience does not match all of the zoning that's being imposed upon us when it comes to housing. We are living lives, basically, oftentimes, in violation of the zoning codes that cities have imposed upon us. And I think this tells us a lot of one of the major sources of why we can have fair housing, but we don't have sufficient housing in California. Now, I told you none of my neighbors are living in accordance. I'm the only one that actually uses their house just as a house along my road. I'm not, just so it doesn't come across that I'm some goody two-shoes. This is my law office where I practice with Liza, Chris Brancart, as well as Haley Parsley and Matt Dahl, who work as for housing legal fellows. And of course, as you can see, it's just a house up the road. Me, like my neighbors, are not using the properties where we live as they are zoned for their intended use. And I think that is the problem, and the nut of the problem, as it were, the center of the problem is why it is that we are unable to build sufficient housing or provide housing access to individuals in California, in spite of the fact that we have the best for housing laws in the world, in spite of the fact that we've come so far. And what is the source? Well, I guess I should say, what is the result first? Look, many of you have, in going through college, at some point, you go through a sociology course or a planning course, and you read Jacob's book, The Death and Life of Great American Cities. If you continued your studies, you may have seen this book, The Dream Hoarders, came out of the Brookings Institute about 3 or 4 years ago, in which it essentially said zoning laws and other privileges that are afforded the so-called professional or chattering classes in the United States are actually excluding most Americans from access to education and housing and other opportunities. In other words, what Reeves said in his book, The Dream Hoarders, is that, well, the Occupy movement may complain about the top 1%, that maybe it's the top 15% that has set up and controls many of the rules that allocate benefits and burdens in the United States. And the best and clearest example he offers is zoning, exclusionary zoning. This point that access to housing and providing additional housing is one of the biggest determinants of opportunity was I think well expressed by Charlotte Vision in her place not race. She is not one to say that race is not one of the determinants of opportunities allocated in the United States. But what she does say is that one of the larger determinants where opportunity is found is where one lives. The fact is that your zip code is perhaps the best predictor of your educational opportunities, your employment opportunities, and also your health and longevity. How did we get into this place? And what is the result? Well, one of the things we know, if we take a look at the data that's put out by the American Housing Survey by HUD, is that three things come about. One is that for those Americans who actually own their homes, they tend to be relatively happy with the housing market in their neighborhoods. The challenge, of course, becomes when you move to a state such as California, where housing has become so scarce and beyond reach of most Californians, and specifically when it comes to renters. We are now going to be a dominantly renting. Most people are going to be renting their housing, and in California, that has become prohibitively expensive. It especially affects young people, millennials, trying to start out. And as you can see, they are dominated by 35%, 34% own, 66% rent. What is the source of this problem? When we speak about zoning and zoning history, I spent time telling you about the Buckham case, a case that is extremely important from the perspective of fair housing. But the reality is, it doesn't receive much attention. What does receive the attention is a case called Euclid. And I think this is where the source of our problems begin. In Euclid, just at about the same time, the Supreme Court came down with the Louisville case we discussed at the top of the hour. In the Euclid case, the Supreme Court was asked to determine whether or not it was constitutional to impose zoning uses and zoning segregation within a municipal government. And this is the village of Euclid. Here was its map. And what they decided to do for the first time was they decided they were going to break up their city into different tracts. There's going to be, as you know, common in most of our cities, there'll be a commercial district, there'll be a residential district, a business district, and then within the residential districts, there's going to be different types of housing based upon density. There'll be single-family dwellings, multifamily dwellings. We're not going to mix apartments up with single-family housing. We're going to go ahead and have them separate. The case of Euclid stands out as something that every law student learns reads in their first year taking a property course. But it's striking how it came to dominate. It came to dominate the discussion about what was appropriate zoning. I say that because it comes down at the same time as the Louisville case, and it also comes down at the same time that Los Angeles is dealing with its own notions of how to apply Euclidean zoning or separate uses and segregating housing based upon size, type, and quality. This is a advertisement for Victoria Park. It was one of the first early subdivisions near downtown Los Angeles back in 1912, 1913. What Victoria Park wanted to do to create this, what they saw as a model community, as you can see, standard subdivision layout, is they had a problem, and that is that adjacent to the subdivision was a brickyard. Brickyards were common in that day and age because many of our, well, most of our housing here in the West that wasn't built with redwood was going to be built out of brick. And the developers of the Victoria subdivision went to the city of Los Angeles and had an ordinance passed that imposed upon that area a restriction that only housing and housing of a certain type, single family dwellings, was going to be permitted, and that the brickyard would have to leave the area. And in fact, this is exactly what happened. Beginning in 1910 and then all the way through to until the cable cars were pulled out of Los Angeles, you see what emerges is a growing use of aggressive use-based zoning based upon districts within the city of Los Angeles. And I think this, this is the core challenge right here, that regardless of how we feel about the use of municipal power to go ahead and zone, for example, maybe some very logical separations between commercial districts and residential districts, between industrial districts and residential districts. One of the most insidious aspects of municipal zoning has been the separation of housing types and quality within our California cities. In other words, the notion of having single family zoning and multifamily zoning, the notion of having restrictions on the size of housing and lots within our cities. Now, you have heard, if you've been watching some of these series, some of the tremendous great work that's being done by planners to try to go ahead and alleviate the housing crisis and open up housing opportunity for all the folks in Kern County and Bakersfield based upon trying to meet their RENA requirements, based upon trying to bring affordable housing into the neighborhoods and tapping into state and federal funds to do that. Here's what I want to leave you with today. We will never solve the housing crisis in California so long as we allow local municipal government to regulate the location, size, and density of residential uses, that is housing for our people. Let me be more specific. Because we have such vast wealth inequality in the United States, something the state of California is not going to be able to solve. That's a larger question that could be solved in Washington, but is unlikely to be solved. What that means is that you are going to have segregation of housing based upon the type and density of housing, and you're going to have less housing in many areas because individuals with a significant amount of money want to avoid high density and et cetera, et cetera. We can't fix that problem. Kern County can't fix it. Bakersfield can't fix it. State of California can't fix the wealth inequality. It makes some changes, but can't really put a big dent in it. What it can do, however, is prohibit local governments from using their zoning power to restrict the nature and type and location of housing in our cities. I think we have to do that in two ways. First, I think it is time that we repeal single family dwelling zoning, the so-called R1 zoning. I think that it has been successfully done in Minneapolis. I think it's been done in the state of Oregon. And I think that as long as we allow people, municipalities to enforce single family district zoning based upon the nature and type of housing, we will never produce sufficient housing. People with money will not surrender to use the funds that they have to buy that housing, even if it means that we're ultimately going to be depriving a significant number of folks in California from housing. That's point one. Here's point two. We spend a lot of time writing consolidated plans talking about affirmatively furthering fair housing. We've adopted in California an affirmatively furthering fair housing law. We have a tremendous effort being put into by the California State Department of Housing and Community Development to enforce that requirement, as well as the requirement that general plans reflect a housing element in all our cities or zoning authorities that provides for, or at least plans for, I shouldn't say, plans for the development of affordable housing. But here's the problem. We can continue to write those reports. We can continue to enact legislation that has these lawful, laudable goals. But until we mandate that every general plan, which all zoning has to conform with in California, every general plan of every city, embeds in it a required finding that every zoning decision, then whether it's a conditional use permit, a special use permit, or a zoning ordinance, until we mandate that one of the criteria that has to be met is that this decision affirmatively furthers for housing, and it has to be embedded in the general plan, so it becomes part of the checklist whenever a zoning decision is made. Until we do that, all the reports we write, all the housing elements we write, all of the comm plans we write, all the affirmatively furthering reports we write, or the AI reports we write, are probably not going to make a meaningful difference for the folks in California. So I think that's our challenge. Our challenge is we have a number of laudable goals, but I don't think we've taken the steps we need to mandate enforcement of them. And I think there are two things that we need to do. One, I think it's high time that this notion of single family dwelling R1 districts needs to be eliminated. Second, I think that if we really mean what we say about affirmatively furthering for housing, it's time to get it out of the AI, it's time to get it out of the comp plan, and to mandate that it be part of every general plan of every municipality in California, because zoning decisions, zoning ordinances in California have to comply with the general plan. You put it in the general plan, it's going to become one of the findings they have to make whenever they deny affordable housing. Well, you can't do that if you can't make the finding of affirmatively furthering for housing, or when they adopt other ordinances that restrict access to housing. Well, I see we're almost out of time, and I want to thank you guys. I want to thank you all very much for the time that you've given me here today. I need to depart, and I hope you enjoy the slides. And I'm just going to sign off now. Is that okay?
Oh, sorry, I was muted. I will, if it's okay with you, I could forward you any questions that we had during the presentation.
Absolutely. Please. I'd love to see them. All right. Y'all take care. Have a good week. Bye-bye, guys. Bye-bye.
Okay, so with that, our apologies that we don't have time for Q&A today. Unfortunately, he does have some prior engagements. So if anybody has any questions or any commentary, please feel free to enter those into the question box and or the chat box. I will receive those directly, and then I will reach out and forward those forward. So I don't happen to see anything in on right now. I did have some questions and commentary that occurred. I do apologize for any sound discrepancy that we had. While the virtual world has taught us that there are some benefits to being able to go virtual, there are also the pitfalls of technological difficulty. So our apologies for that. The session is recorded, however, and so hopefully anything that you missed, you might be able to find some clarity in the pre-recorded video. So with that, I'm going to go ahead and end today's Fair Housing Conference. For those of you that have attended all 4 sessions, we have greatly appreciated your attendance. We hope that you found some value to the presentations and with our guest speakers. And if you weren't able to attend all four sessions, do know that they are posted and recorded to our YouTube channel, so you can access them there, as well as our social media accounts. So with that, we're going to go ahead and call it a day. Thank you again for your attendance. Any questions, please feel free to reach out. Have a great day.